What happened in Supreme Court? July. Question. The matter is taken up for hearing. Where is the order of the Supreme Court? Listing a directing the matter listed in April in the month of July. Oh, yes, it's available.
First order.
In the matter is taken for hearing, the counsel appearing to the petitioner, the appellant, submitted that the identical matter is pending before the apex court. The apex court has fixed the matter for direct the registry to list the matter for hearing in the month of July 2023. Registry is directed to list the matter on 19th August 2024. Yes.
In fact, my priority that since there was no stay from the apex court till now, if this matter can otherwise be taken up. Though we had waited initially, my lord, if apex court would pass
when
any
you have
order.
already made a representation before the earlier bench that the matter is connected
My lord.
and there's got to be heard. Now we cannot take a different stand. Having waited
My lord,
so much time, you can wait for another 6-4 months. Yes.
My lord, that is true. That is true, my lord.
Yes.
Oblige, my lord.
Yes.
Item number 2.
Please, Your Lordship. Lordship, the respondents are yet to file their affidavit.
May I please, Lordship? Your Lordship will be filing the affidavit in the course of the day, Your Lordship. In the course of the day, we'll be filing the affidavit.
In the course of the day, you will be filing the
Yes, Your
affidavit.
Lordship.
You serve a copy on hand.
Yes, Your Lordship.
Then on receipt of the affidavit, objection, if you want to file any rejoinder, you file it.
Lordship.
Don't take time the next hearing.
Lordship.
You must understand it's a special bench sitting to
Lordship.
hear the matter. The counsel appealing with the state submitted that
Your Lordship, for the
She's for the district council and for the state. State is a formal part.
appealing with the counsel submitted the district council submitted that they are going to file objection. Today, the other contesting parties are expected to file the rejoinder, if any, on receipt of the objections. Call the matter after 3 weeks. See, if you see who is the appellant?
My lord.
Who is the appellant?
Lordship. Here actually we are challenging the
You are for the writ petitioner.
Lordship. For the petitioners, my lord.
Yes. You take page 21 and 29.
Petition becomes first come to the bench.
Exactly. This is in
1970. Objection.
What about the state? You are not going to file?
Formal party rules.
Only formal party. Yes. Yes.
Hello,
much obliged.
Oblige.
What's the matter? Well, you have the matter on 20th. 20th of March. You saw the papers today.
Yes, Your Lordship.
Any mention? Any mention?
Please, your lordships. Lordship, I beg to mention item number 4, lordship.
Item number,
Item number 4, lordship.
what?
Lordship, I humbly pray that this matter will be listed again, lordship.
Don't mention the matter that are on the list. We don't know who is on the other side. Any mentioning for listing?
Lordship.
See, we have got only 10 cases. So it will be over in another half an hour time. Can wait.
Lordship.
From supplementary list, item number 1.
May it please your lordships. Lord, in this matter, the first thing I'd just like to indicate, Lord, in this matter, notice has not been issued.
So delay of 4 days.
Lord, I'm sorry, my lord, this item number 1. Daily list, my lord.
Food Corporation of India. Food Corporation of India. I think you are calling on the main list.
Mistake.
4 days delay.
Only 4 days, your lordship,
You are appealing?
for the appellant petitioner.
April 4 days. Who is on the other side?
The caveat was there, and we have already served the copy to one L. Imon. And he's
Nobody
supposed
is
to be
here.
present
Name
today.
is printed. Name is printed. Somebody is on the screen. He is not the counsel. This is see, the legalists have been brought on record.
Yes, lordship.
Take notice. Take notice to the respondent. Returnable by eighteenth. Private notice is also permitted.
Okay, lordship. But caveat copy has been served to the counsel concerned, lordship.
But
So
no,
when it is mentioned in the caveat, the lawyer,
we do not know whether he represented the original party or he is going to represent legal hands. Original party he would have represented.
Yes.
Legal hands may not engage him.
no, already they have mentioned, all right, so I've understood, lordship. I'll take steps, lordship.
If your friend, see, you said that the name is also not printed in the cost list. Registry, it is represented by the counsel for the petitioner that the respondent is also entered caveat. She is directed to verify and print the name of the counsel in case there is a wakalat on behalf of the respondent. 18th. 18th of March.
That's much.
See, the other side is there, we would have condoned the delay because only 4 days.
Yes, lordship. All right, lordship, that will, we take step.
Item number 2.
This is with regard to tender, is it not? This is with regard to tender. Tender or the arbitration,
It is
commercial,
contractual matter.
commercial division.
Yes, lordship.
With regard to money suit, you have completed the work because the other person has not done the work.
The other side is defaulting contractor against that, lordship.
Yes.
Much appreciated.
May it please your lordships. Lordships, an application under section
State delay.
for a delay of 1,200 days in preferring the criminal.
Having satisfied the
Obliged.
reasons. given in
Deeply
the
obliged.
affidavit, to condone the delay of so many days is condoned.
From the daily list, item number 1.
Make this, your lordship.
My lord, this is the matter on last occasion, lordship.
Or whether any minor punishment.
My lord, I have instruction, my lord, we'll reconsider it to withholding of 3 increments, my lord.
My lord, the only point involved is here that, my lord, they have made a mention that there is a writ petition pending before the single judge which was filed in prior point of time. No, they approached only after we filed this writ petition and notice has already been issued before the single
The
judge.
matter has got to be reheard. They have to proceed with the inquiry
Lord.
and they will impose some punishment.
My lord, but we have challenged the entire action, my lord, because it has been vitiated. My lord, that is what the subject
That
matter
is,
is
if
challenged before
you want
the.
to file any contempt, you can file a contempt. They disobey the order.
My lord, as far as
Suppose
this,
we pass an order.
my lord,
Suppose we pass an order.
My lord, my-
Single judge cannot take up the contempt.
correct, my lord, that is
Because
what.
the doctrine of merger comes into play.
Definitely, my lord. I do understand, my lord. My entire petition, my lord, where we have stated that the
You
proceeding
want
has
to
been
consider or
initiated.
you want to, you feel that it suffices the punishment.
My lord,
Be on leave for several years.
yes, my lord. There is a, my lord, per se, there is an illegality, my lord. They did not approach this court prior in point of time because, my lord, the order was of 2024. They ought to have complied within 8 months as per the direction of your lordships. My lord, after that, my lord, they have done it till 23 months. They didn't take any action, my lord. Time has passed. Now we stated that since the entire proceeding has been vitiated, we challenged it before the single judge. Now the proceeding is before the single judge on the counts. My lord, they firstly did not approach us, no disciplinary proceeding. Prior to that, there were 2 more forums, my lord. First was the CAT, then division bench order, my lord. The single judge CAT already held that the entire proceeding was vitiated. One more point which they have was is
The
that, my
entire
lord,
proceeding is vitiated.
my lord,
The matter will have to go before the authority for considering afresh, either de novo inquiry or from the stage where the defect has been pointed out.
correct, my lord.
If they do it again, you will be facing one more round of litigation and they may impose some other punishment or very same punishment.
But, sir,
Then you are going to litigate for another few years.
my lord, since we are before my lords, my lord, we would seek some protection only on the count that, my lord,
That is what we are saying. Give a quietness to the matter, accept the punishment and go ahead. They are going to impose stoppage of increment for a period of 3 years without cumulative effect.
My lord,
in that regard, my lord, may I have some instruction? Because today, my lord, in this matter, notice was not issued. I am only just under instruction to place this thing that, my lord, since the matter is pending, will come with the instructions on the next date as my lord.
Last time, I think your junior appeared.
Correctly, my lord, correctly, my lord.
In fact, he said, don't say that your senior is going to come. You have to come and do it. This is what he
Absolutely,
said
my
last time.
Yes, my lord. On that day, my lord, we didn't have any instruction. We were appearing only.
I can't forget.
Yes, my lord, your lordship is right in remembering so. And my lord, this matter was since listed on the same day. The single bench matter was also listed on the same day. So, my lord, we had instruction that let the matters. Otherwise, your lordship can very well take that matter of single judge. If your lordship wants to decide.
On the matter also,
My
last time what we
That
said
would be
was,
good, Lord.
last time what we said
Yes,
was
Lord.
that by imposing the lesser punishment,
My lord.
ultimately the charge is approved. What is the punishment you are going to impose?
Correctly, my lord.
They said stoppage of increment. Now they say stoppage of increment.
My lord.
If this is imposed, that writ petition becomes infructuous. We can
Becomes
call the writ
infructuous.
petition and close it.
Yes, my lord. So, my lord, let the matter come before my lord. My lord, on the next day, we'll praise the instruction. My lord, if he is happy with that increment stoppage, my lord, your lordship can very well decide that matter. My lord, only the point that we are not on the notice, and my lord, the party needs to be consulted. Only that part your lordship will kindly allow us.
Taken time. Already you should have contacted your party.
No, well, that is the thing, my lord. Since we were not under notice, notice has not been issued in this matter, my lord. That is what, my lord.
She was there.
Yes, my lord.
I asked her to get instructions.
Yes, my lord. That instruction, my lord, on the count because, my lord, we received this copy today morning, my lord. This petition itself was not served to us, my lord. That was the point.
Otherwise, we'll pass an order taking note of the Janakiraman case, saying that we'll modify the punishment, which is shockingly disproportionate.
No,
Instead of
that is
remanding the matter and bring down the life of litigation. In order to give a quietness to the matter, we'll say that the punishment of stoppage of increment for a period of 3 years without cumulative effect.
My lord.
Suppose they are going to impose the same punishment with cumulative effect, what will you do? You will be losing pension and other benefits, whatever you are entitled to.
My lord, that is what, my lord, I leave it to my lords. Otherwise, because, my lord, the only point is that, my lord, the party has to be informed. That is he quite convenient with that part of
You
punishment.
take a decision.
My lord.
Why should you take the consent of the party?
My lord, at least that part of lordship may look into, my lord. I pray, my lord.
Tomorrow.
My lord, I'll be appearing through VC, my lord. I'm an outstation lawyer, my lord. I'll be appearing through VC then.
You can come through online.
My lord, that is what. I'll come through online.
We never say that don't come, you should come only in person. Hybrid mode is always available.
Always available. I'm grateful for that. You're blessed.
COVID has created a lot of problem to us,
Yeah.
and it has also given good things to us. So far as the judiciary is concerned,
Yes, sir.
COVID has given the
But this
technology
benefit, definitely, my lord. It has come
to
because of
anywhere.
anywhere.
My lord,
In fact, in one occasion, the present Chief Justice of India, Justice
Yes, sir.
Chandrachud, the meeting said,
Lords.
I would like to hear the lawyers from the subordinate court,
Correct.
because they are able to present very well than the persons who are before this court.
Do agree, my lord. Like, but that was
That's why
the.
everybody who is sitting here want to encourage the juniors.
And
Yes,
but I would pray, my lord, the other writ petition can be called for, my lord.
yes, my lord.
The other writ petition before the one
we
single.
call the matter. Registry is directed to post WP number so and so along with this.
1 of 2024.
1 of 2024, my lord, WBC.
Monday.
Monday, my lord. Maybe, my lord.
We'll finish the matter.
Maybe, my lord. I leave it to my lords.
1 minute, one.
Maybe.
Tuesday.
Tuesday, my lord. I'm grateful. Highly blessed, my lord.
Convince your party.
Surely, my
They
lord.
must know. You must convince the party.
Definitely, I'll try my best, my lord.
See, sometimes sitting here,
My lords.
we are doing the mediation,
I do appreciate, my lord. I do appreciate.
which will be the final one.
Rightly, my lord.
So,
I'll
for
try to
parties
convince, as has fallen from my lords, my lord, I'll definitely try to convince him, my lord. If that was highly blessed, grateful to lords.
Item 2.
May I please, Lordship? Lordship, this writ petition will pertain to whether GST will be applicable on royalty. As regards royalty, Lordship, there is a matter pending before the Honorable Supreme Court, the 9-judge bench.
Pending.
Lordship, it is pending.
When is it listed or likely to be listed?
Lordship, the hearing
Hearing
has
is going
commenced,
on,
but
my
since it is
July.
9-judge bench, so it might take some time for the judgment to be delivered, Your Lordship.
It is represented that the issue, identical issue is pending before the 9-judge bench or Supreme Court. Registry is directed to list the matter after
But
Lordship,
hearing is
2 months
commenced in the
after
Supreme Court, my lord.
giving liberty to
Hearing is already
mention,
started, my
Lordship.
lord. I saw on the YouTube, hearing is already started,
already started.
my lord.
Liberty can be
Study
given to
hearing,
parties to mention the matter.
Exactly, that's what we are going to say.
After 3 months, my lord,
So when it is represented by the parties that the matter, identical matter is being heard by the 9 judges of the Supreme Court. Full stop. Matter is adjourned sine die. After the disposal of the matter by the Supreme Court, the parties are permitted to mention
my lord.
in order to enable the registry to list the matter before the court.
My lord.
Deeply obliged, Lordship.
Adjourned sine die portal.
Item 3.
Lordship, the judgment is awaited from the Calcutta High Court so far as the revocation of the probate is concerned.
Yes, what happened?
Lordship, the judgment is still awaited. Judgment is awaited.
Matter has been heard.
Matter has been heard by the Calcutta High Court, Your Lordship. Now we are still waiting for the judgment.
So it has got a bearing on this.
It has a bearing on this matter.
My lord.
When the matter is taken up for hearing, both parties submitted that the identical issue has been heard by the bench at Calcutta, by the Calcutta High Court, and that the decision will have a bearing. It further stated that orders have been reserved. Or reserved or
Yes, already reserved.
orders have been reserved.
Reserved.
Full stop. Registry is directed to same sir. Adjourn sine die permitted to mention after the orders are pronounced by the Calcutta High Court.
Much. I leave it.
Item 4.
The listing matter and adjourning it is not going to. Once it's
We will
over,
mention
you can
it.
mention.
May it please your lordship. Criminal appeal, my lord, sole convict, my lord, preferring this appeal. Paper book to them.
Who's on the other side? I'm there.
Yes. Now, more now here in this case, my lord, certain facts before taking this honorable court to the paper book. My lord, date of occurrence is 29/12/2011.
1 minute.
29/12/2011, my lord. And there is a missing entry given by,
1 minute.
yes, given by two persons, my lord. That happens to be PW3 and PW4. And the FIR has been lodged on 31/12/2011.
1 minute. 1 minute, sir.
Yes.
28. Yes, sir. Yes.
Yes. Missing, the person, the deceased was missing since 29/12/2011.
Deceased.
Deceased was missing.
Deceased was missing. Murder case.
Murder case, yes. This is a murder case, my lord. 29/12/2011, he was missing. FIR has been lodged.
The missing dates are, sir, I did.
29/12/2011.
Oh.
And the FIR has been lodged on 31/12/2011. Now, informant happens to be PW3 and PW4, mother of the deceased and the wife of the deceased. Case was registered, my lord, on 14/2/2012. The accused was arrested, my lord, on 28/12/2012.
After 10 months.
Yes, he has been arrested. Charge sheet has been submitted on 29/7/2015 against two persons, my lord.
Charge sheet?
Yes, on 29/7/2015.
29/7/2015.
Now, charge sheet against two persons, my lord. The appellant and another, my lord, Nidamon Chulkat. Chulet, yes, difficult for me to pronounce, my lord.
Two persons. Yes.
Now, charges has been framed under 302/34 of the Indian Penal Code. Now, here the prosecution examined 13 witnesses, my lord, including the MO, IO, and everyone, my lord. And the defense examined none, my lord. His plea is complete denial of the allegations. Whole case raised upon, my lord, the version of two eyewitnesses, my lord, who, according to the eyewitness version, immediately on the date of occurrence, seen this accused appellant beating the deceased at a place. Immediately, these two persons came in and informed PW1 and PW2, PW3 and PW4. With regard to the incident, they have seen it. Now, my lord, after registration of the case on 31/12, the name of this appellant is missing in the FIR. Now, my lord,
name of appellant is missing in the FIR.
Missing in the FIR. It has been disclosed that so and so has beating the deceased at this place. This has been informed to the informant on 29/12 itself. On 31/12, FIR has been filed, their name is missing. Now, my lord, all these witnesses have been examined. Shocking part is the two eyewitnesses, my lord. I'll take this honorable court. Absolutely shocking, my lord. This PW1, he has been examined, my lord. His 161 statement has been recorded after 65 days of the date of occurrence.
Statement recorded after
65 days, my lord.
PW1.
PW1 and PW2.
Both after 65 days.
65 days. Till 65 days, they will come, my lord. They did not come before the investigating officer, they did not even made any effort with regard to this. The question of being given threat by this accused person is not been there, not existing. Interestingly, my lord, it's not on evidence or record. That has been brought in by way of RTI Act that initially accused was someone else. The name appears is someone else. I'll take your lordship to that. Now, he's never been investigated. What happened to him, my lord? That's been a closed chapter. And my lord, shockingly, my lord, here, I take your lordship, postmortem has been done. This is house. Postmortem has been done in this is house. Now, as per the version of PW1, PW2 and PW3, PW3 and 4, my lord, the informant, body was recovered on the next date. Whereas inquest been done subsequently, my lord, at the place of occurrence.
Body was recovered the next day.
Next day, my lord. I take your lordship to this. And the inquest been done.
In this case, 201 is there now.
My lord?
201 is there.
What is it? 201 is not there.
Yes.
Now, this is the quality of the evidence on the basis of which I have been convicted, my lord. Now, may I take your lordship to the evidence on record, my lord? Now, charge at page 21 of that paper book, my lord, will kindly come to that, the typed copy. Under 2 head, my lord, 29/12/2000 committed intentionally causing the date of deceased so and so, so and so. Second is 34, my lord.
Page number, sir?
21 of the paper book, my lord.
I need to filter it.
Yes.
Yes, these are the charges, my lord. Now I come to the evidence part, my lord. Now, that part, my lord, PW1 at page 29, my lord, will kindly come to. His 161 is also been made part of the paper book, my lord.
150?
161 statement.
Page number?
29.
PW1 is not.
No, that is PW3. PW, this one. 7 Pirang.
29, sir.
20, page 19, yes.
Page 31.
31. I'll come to that. I am taking this honorable court through the 161. Examining stated on 31/12, police inquired about the dead body of say so and so, so and so. Body was recovered on 30/12, brought to the house, and 31/12/2011, police inquest over the dead body of say so and so, so and so, all being identified in presence of who was murdered by the unknown person at Birwa on 29/12/2011. Now, my lord, page 31, my lord, will kindly come to page 31 of this particular two eyewitnesses. 30 and 31, my lord. Same thing, my lord. 29/12, 30/12, my lord, he came to know that brutally tortured and murdered unknown persons. The next part is, this is the eyewitness. He's been examined on, my lord. Date of examination is 3/3, my lord.
She's the complainant.
The complainant, my lord. She is the informant in this case. Dorshila Piranga. Yes. On examination, she stated that she is the mother of Sri. My lord, page 30.
Page 30.
Yes. The second part, my lord, informant, one of the informant.
Srimati Dorshila.
Yes, Dorshila, my lord.
No.
Mrs. Dorshila. She is the mother of so and so. She stated on 21/12/2000 night time she received information from Reniki Paslin, wife of so and so. Her son, Sri so and so has been beaten by some unknown persons at Briwa. Accordingly, on receipt of this information, she informed the elder at the village at so and so to helping her for searching for her son from Briwa. At the time, all the elderly so-and-so goes to Brewer and searching him, but on searching, they found the dead body of so-and-so lying there on the roadside on the way to Brewer to village carried so-and-so, so-and-so. This is a statement. And at page 31, my lord, will tell is come to my lord. Is the another informant, my lord, 2 persons have lost this affair. That is Srimati Rineka.
So the another information.
Informant, yes. On examination, she stated that she is the wife of so-and-so. She stated 29/12 night, she received a telephone from so-and-so. Or Brewer, some unknown person assaulted him. Accordingly, on receiving the information, she left to the house at her mother-in-law and informed her regarding the incident where Brewer to her husband and asking her for help from the villager. According to the villager, also goes to Brewer and searching so-and-so. But on searching, they found the dead body of Brewer lying dead near the roadside on the way of Brewer to site and carried the dead body to the village for performing the last rites as customs. Now, my lord, this statement has been recorded, my lord, with regard to this, my lord, that on 29/12 itself, the dead body, according to them, is being recovered. Now, next witness, my lord, happens to be the eyewitness. Rilang, Sri Rilang, my lord. On examination, he has been examined after 65 days. On examination, examining him, he stated on 29/12 at about...
He was examined after 65 days.
65 days. Now the informant doesn't say that these persons came in on 29/12, informed their informants. But this witness comes after 65 days and this statement was recorded. On 29/12/2011 at about 9 p.m., he was present at marketplace as Brewer. He had met the victim, Sri so-and-so, and he was beaten, assaulted and killed. After talking with him, he went to his own way. After some time, he heard people saying that someone was being beaten by some man. He rushed to the spot and saw the victim lying unconscious on the ground. He was bleeding from his face. At that time, he saw Tom of Sangrun village. Only Tom of Sangrun village, that much it is, who was still hitting the half-dead man. That market of Brewer belongs to Sri Tom. He also not known his title, but only his name and village. The deceased and myself belong to the same village. Therefore, on seeing what has happened to him, he left the spot and went straight to the village and informed his parents. Very important. Parents is, my lord, the mother. Parents happens to be the wife of the deceased. They all went to the spot, but his dead body was taken somewhere else. We then returned to our village so-and-so the next day on 31/12/2011. The whole village went to make a search, and at about 2 p.m., we found the dead body of so-and-so and took him to home. On 31st December, the FIR was lodged and the police came to conduct postmortem at his house, so-and-so, so-and-so. This is very important. The next day, 31/12/2011, my lord. Before that, 29/12, body has been recovered. The next eyewitness, my lord, happens to be the same, my lord, another person, Sri Kom, Sutna. Same version, my lord, after 65 days.
Here, this person also
65 days, my lord. On the same date, 161, forwarded to the court, my lord. I'll come to the court. 164 statement, shocking, my lord, eye-openers. On examination, he stated that on 29/12/2011, at around 9 p.m., he was present at marketplace at Brewer along with victim so-and-so, where he was assaulted and killed. After talking with him, he went to his own way. After some time, he heard people saying that someone was being beaten by some man. My lord will kindly see word to word with regard to other eyewitness is same. He went to so-and-so. After some time, he heard people saying that one being beaten by some man. He rushed to the spot and saw the victim lying unconscious on the ground. he was bleeding from his face. At the time, he saw Sri Tom of so-and-so village who was still hitting the half-dead man. That marketer brewer belonged to Sri Tom. On seeing what had happened to him, he left the spot and went straight to the village. That's all is his statement. My Lord, can you see? Now in the court, he comes in and he goes and informs the parents also, informant PW2 and PW3. This is very relevant with regard to this. Now I take this Honorable Court to the substantive evidence. Before that, my Lord, I take this Honorable Court to the 164 that has been recorded, my Lord. Can you see? At page 36.
36?
Yes. Of these two eyewitnesses, my Lord. PW1 and PW2. Page 36, PW1's 164 statement. Date is very important, my Lord. Can you see? 3rd day of March 2012. On that day, 161 statement has been recorded, and it is 65 days. On 29 December, at about 9 p.m., I was present at marketplace at so-and-so. I had met the victim, Sri so-and-so, before he was beaten, assaulted, and killed. After talking with him, I went my own way. After some time, I heard people saying that someone being beaten up by someone. Along with so-and-so, rushed to the spot. So now he introduced another eyewitness to be with him, my Lord. That is not in 161. Rushed to the spot and saw the victim lying unconscious on the ground. He was bleeding from the face. At that time, I saw Tom, so-and-so, who was still hitting half-dead man. That market brewer belongs to Sri Tom. I do not know his title, but only his name and village. The deceased and myself belong to the same village. Therefore, on seeing what has happened to him, we left the spot and went straight to the village to inform his parents. That is on 29/12. We all went to the spot, but the dead body was taken somewhere else. We then returned our village so-and-so. The next day, 30/12, the whole village went to make a search, and about 1 to 2 p.m., we found his dead body at so-and-so and took him home. On 31st 12, 2011, FIR was lost and the police so-and-so. Now, with regard to the deceased body, now it comes to 31/12. From 30/12. Now, my Lord, at page 37, my Lord, will kindly see the 164 being recorded in what manner, my Lord. I'm sorry to say. Date of recording, my Lord, at page 37, kindly see the date of recording, 2nd of March 2012. And what is the same statement as given that of Rilang. Rilang has been recorded on 3rd. Page 37, my Lord, will kindly see 2nd of March it has been recorded. And Rilang's statement at page 36 is been on 3rd. So, my Lord, what has been going on, my Lord? I couldn't understand, my Lord, that the learned people will explicitly submit all this. Same statement as given by that of so-and-so, 2nd of March 2012. So, his statement has not been recorded till that. On 3rd, it has been recorded. On this basis of evidence, my Lord, a person has been convicted under 302. My Lord, can we come to, my Lord, the evidence of PW1? I have received someone to depose in court that I could not recollect the date and time of the incident. I heard people talking about the assault. That is page 39.
It's going to take time, but we can see it. 1 minute. What about the... What is the next case? The other one, not yours.
It's about gratuity. It's about gratuity.
Oh, gratuity.
Watch it.
You're ready. Both of you are ready.
Watch it.
Lordship, McAuffer is the main contesting party. McAuffer. He's there. The council is here.
They're ready.
He's ready, Your Lordship.
Ready means we'll take it up. Otherwise, we don't want you to wait.
Watch.
Yes. Okay. After this matter, we'll take it up. Not a problem.
May I proceed, my lord?
Yes, yes.
I have received someone to depose in court today. Now, my lord, this witness been examined on 19th
10 December.
10 December 2021, my lord. I have received someone, I could not recollect the date and time of the incident. I heard people talking about the assault incident happened in so-and-so, and I myself went to the place where I saw the victim, she so-and-so was bleeding and lying on the ground. I also, there were many people surrounding the body of the deceased victim. I saw Sri Tom was still hitting the half-dead man. I do not know the surname and the resident of the person named Tom. That I and the deceased belong from the same village. After I saw the incident happen, I rushed to the village so-and-so to inform his relatives. After I have informed the relative, I along with them went to the place of occurrence. Again, on reaching place, we could not see the body of the deceased victim anymore. On the next day, the whole village went to the charge of the body and it found somewhere nearby so-and-so. Exhibit 1 is the statement. Exhibit 1 is my signature thereon. Now, my lord, incident in December month, my lord, he has been examined, my lord. He has not disclosed this till his recording on 3rd day of March 2012, my lord. And this is more than, my lord, January, February, my lord, then March, all these days. Now the cross-examination part. I do not remember the date of incident. The incident happened at night, 9 p.m. Someone were fighting at the place, fighting so-and-so. At first, when I saw the fight, I did not know who were fighting, but until I used my torchlight, then I see them. The victim was my co-villager. I did not help the victim. No one from the people surrounding the fight helped. After I used my torchlight and saw the fight, I ran away from the scene. I went home, personally informed his family. It is correct that I saw the deceased person lying on his side on the ground. I could not say the deceased person was already died. It is not a fact I did not went back to the place of occurrence. It is a fact that I heard from people that there were fight going on. It is a fact that I heard from the people saying that the deceased person was beaten. It is not a fact that I do not know the accused. It is not a fact that the incident which I had informed the relatives of the deceased is not true. At the time when the fight was going on, I only assumed that the victim is dead. It is not a fact that I did not see the person fighting, but just hear it from people. But actually, when I used my torchlight, I had seen with my own that Tom was fighting with the deceased. I know the accused person, Tom, prior to the incident, and I have met the accused twice or thrice along with the victim. After I left the play, I do not know what has happened, my lord. He even went to the extent of talking to the deceased. He talked about my lord hearing and returning and saw. And in his evidence, my lord, substantive evidence, he even talked about going to the place of occurrence, my lord, when this assault, alleged assault been taken place, along with PW2.
Yes.
Now, the next witness is 41, another eyewitness, my lord. I have received someone to depose in court.
One is an eyewitness, PW2 is another eyewitness.
Eyewitness, my lord. And again, my lord, 65 days. Not been disclosed to anyone. I have received someone to depose in the court today. I could not recollect day as it happened long time back, but I remember that the incident at the night time of the incident, I was present at so-and-so market. I saw people gathering there, and I heard them talking that the victim, deceased person, was beaten up. On reaching the place of occurrence, I saw Tom was still hitting the deceased person, and I ran away as I was scared to see the incident happen. On the same night, I went straight to the village of the deceased person at so-and-so and informed his relatives that the deceased person was beaten up by Sri Tom. But I do not know his surname and the resident. On the next morning, I went to so-and-so. On reaching there, I did not see the deceased person, on which later I came to know from the people that the victim was dead and his body was found somewhere nearby Biwar market area. My statement recorded so-and-so is the statement, exhibit 2 is my signature thereon. I can identify the accused. He is present in the dock today. Cross-examination. I do not remember the date and year on the incident, but I do remember the incident happened at night. I know that this is person. It is the fact that I heard that there was a commotion and I went to see. I only heard that there was a fighting going on, so and so. After I saw the fight, I ran away from the scene. I only saw people running and I also ran along with them. I also informed the family member of deceased and he was beaten up but not killed. It is the fact that I was only informed that the deceased died, but I did not see who killed him. Re-examination. On reaching the place, I saw the deceased victim was lying on the ground, unconscious, and he was bleeding from his face at the time while the accused Tom was hitting him. Cross-examination. It is not a fact that I did not see the victim bleed at the time of incident. It is not a fact I did not recognize the so. Now, these are the two eyewitnesses, my lord. So far, with regard to these two eyewitnesses, my lord, I will come to later on with regard to the law with regard to this, that how to be dealt with a person who happens to be eyewitness, who never at first point of time disclosed with regard to occurrence, what will be the evidentiary value, my lord. Now, next is page 43, my lord, PW3, my lord, Dorothy so-and-so. She is the informant, one of the informant, my lord. I have received someone to depose in court today. I know about the case as I am mother of the deceased victim and also the complainant in this case. On 29/12/2012, as usual, my son came out from home to work in so-and-so, but at around 9 p.m. I received a telephone call from my son's wife, Srimati so-and-so, asking about the whereabouts of my deceased son, and I told the wife that maybe the deceased son was still at work. Now, this is a contradiction, my lord. It's never been in the 161 statement. After talking to my deceased son's wife, two men came to my house, namely so-and-so and so-and-so. This happens to be two eyewitnesses, my lord. And informed me that my son, the deceased victim, was murdered at so-and-so. On inquiry whether they know the people behind the murder, and they told me it was Tom who murdered him, but I do not know about the details of Tom. This is a contradiction, my lord. In their previous statement, I have taken your lordship, this is never been stated, my lord. And on the face of the record, an exhibited document, the FIR itself doesn't disclose about this. They talk about the missing. I'll take your lordship to the FIR at last. Now, thereafter, my lord will kindly see. After I heard about this news, I went to the neighbor's place, calling them to accompany me to so-and-so, but we could not go, and it was late at night. However, my husband late so-and-so went to the place of when my husband reached the place of occurrence. We could not find the deceased son, and he returned back home on the same night. On the next day, my family along with villager of so-and-so village went to the house of the deceased victim and found his dead body, and I do not know the place from where they found the dead body, as I do not went along with them. On 31/12/2011, police came to our house and took the body of the deceased victim for postmortem at so-and-so Sutnaga Civil Health CHC, Civil Health Clinic. Okay. And on the same day after the postmortem, we took the deceased back home and conducted the last rite. Again on 31/12/2000, I filed the affair and put my signature and hand over the copy of the affair so-and-so who were present in the house at the time. Exhibit 3, P3 is the affair, Exhibit P3-1 is the signature thereon, my lord. The cross-examination part, my lord. It is true that I filed the affair after the delay of 2 days from the incident. On 21/12/2011, I received the information about the victim of two persons, namely so-and-so, as they came. These are the two, my lord, eyewitnesses. Admitted, my lord. As they came and informed me in my residence. It is true that I found the dead body of the victim on 30/12. Next day it has been found. It is true that after we found the dead body of the victim, we took the dead body of the victim to his wife's residence. It is true that when the dead body was taken home, we had performed the last ritual as per customs. We have given the dead body bath. We cremated the dead body on 31/12/2011, 4 p.m. On 31/12/2011, I do not remember the time. After the police arrived at his wife's residence, the dead body was already in the coffin. it is not true. I received the information from the wife of the victim. I received the information 29/12/2011 that my son was beaten up at Brewer. The elders of the village went to the search of the victim but do not find the victim and do not know why the elders do not file the FIR. I did not see any police at the residence where the victim body was kept. The two informant came at my residence at around 9 p.m. to inform me about the incident. This is eyewitness, my lord. It has never been in the 161 statement, my lord. Now, another, my lord, informant at page 45. I received someone to depose in court today. I know about this case. I am the wife of the deceased victim. I am the complainant in this case along with my mother-in-law, so-and-so, so-and-so. On 29/12, as usual, my husband left from home in the morning to work at Brewer. Usually, my husband came home from work evening before 7 p.m. However, on the particular night, my husband did not return home, and about 8:30 to 9 p.m., I called my mother-in-law to ask about the husband, and she said that they may be, deceased is still at work, and that he will be coming home. On the same night, after a while, a group of people from my village came to my house, and when I asked them as to why they came into my house, they did not tell me the reason until the next morning. They told me that my husband has been murdered, and just after I heard the news, I felt unconscious. This is for the first time in the court. 30/12/2011, the elders of my family and the villagers of so-and-so went to the search of my husband, and they found my husband's body somewhere nearby area of Brewer. They brought the deceased dead body to my house. I cannot explain the condition of my husband's body as I remained unconscious even at the time of the arrival of his body in my house. On 31/12/2011, the dead body of the husband was taken to so-and-so CHE for postmortem, and just after the postmortem, we took back the body of our village for funeral. Also, the same day, I handed over the affair to the police at so-and-so, so-and-so, so-and-so. I heard, next page, my lord, I heard that it was Tom who murdered my husband. My lord?
1 minute.
Yes.
Shall I cut you tomorrow? Tomorrow.
My lord, I am.
I've got another bench.
Oh, my lord. Can I do it online, my lord, from Guwahati? I'm staying in Guwahati, my lord. Can I do it online?
You can come online. It's not a problem.
Yes.
But if you come personally, no.
That becomes easier, my lord. Then may I pray for fixing it on 6th, my lord. 6th of March, my lord.
6 already we have fixed some matters.
There is a POXO case wherein I will be appearing, my lord, to assist this honorable court. So, first of all, we will complete this, my lord, and thereafter, my lord. Kindly accommodate that, my lord.
Yes.
Yes. Deeply obliged. Deeply. It's part heard, my lord.
Yes.
Deeply obliged.
It will be on paper as parted, but we have fully heard.
Yes. Deeply obliged.
Item 7.
I take the lead.
These are important. No?
Tinggal mengerti no. Sip, alut pala. Will stand. Will stand. Yeah.
Yes.
Please, Your Lordship. Lordship, the appellants are before this Honorable Court, my Lord, for the entitlement of gratuity and leave encashment, my Lord. Similar benefits has already been granted to the similar situated persons, my Lord. I have also filed my statement as per Form I, my Lord, and a list of dates has also been filed, my Lord.
Yes.
Please, Your Lordship. Lordship,
We'll take it tomorrow. We got only 5 matters. We'll take it up tomorrow.
No.
From the list, item number 1.
I'm sorry, my lord, lengthy written submission was filed. I filed short one, my lord. 4 pages, my lord, now.
Where do you want? When do you want?
Yeah, I have already filed, my lord. I have already, your lordship, directed filing of small written notes.
Yes, yes.
I have already filed. And I have concluded my argument, my lord. My friend has to argue.
Well, now, look, three issues.
We'll take up your case, just pass over. We'll call the next case, whether they are also ready, we'll ascertain.
Yes.
So in item number 2, my lord, I'm praying for some accommodation, my lord. Maybe listed next week, my lord, any day.
The second item. What is the matter about?
This is a rate appeal, my lord, arising out of. This is a rate appeal, my lord.
Arising out of?
Arising out of order passed by the single.
They are claiming pensionary benefit, your lordship.
Pension.
They are claiming pensionary benefit, your lordship. They are deficit school teacher. All retired, your lordship.
All retired deficit teachers.
Monday.
Man.
Monday. Offline.
Retired school teachers. Yes. Which one? So second item appears to be condoned delay, no? Delay need to be condoned. How many days delay?
122 days delay.
Do you have any objection for the delay being condoned?
We filed an objection, my lord.
We filed the objection, your lordship. Only the explanation, your lordship. My humble and respectful submission is not sufficiently explained, your lordship. Your lordship, that is my contention only, your lordship.
We'll condone the let it now be numbered and come up.
Lordship.
We use that judgment of Supreme Court. Think that a longer delay explanation. Yes.
They will come for admission, your lordship.
Yes, admission on Monday.
Online.
Yes.
My lord, my first point, my lord, to reply to learned HE's argument, that the issue with regard to collection of the customary tolls by the respondent here had already been settled between the same parties in earlier round of litigation. And that judgment, my lord, may refer to that. I may come to compilation number 2, volume number 2, man. Compilation number 2, page number 163. The same party, my lord, had filed the writ petition in 2013, and the order was passed. Page number, my lord, 161. The certified copy. 161, volume 2.
Yes.
162, my lord, the parties' names are reflecting. State Dharma Starship, the same writ petition. Here the same respondent versus State of Meghalaya. Now the issue involved the same. The next page, the order passed by the earlier court, the High Court. Well, it's a short order. With Lordship permission, may I read?
162,
Yes.
the writ petitioner has already approached this court of
Yes,
earlier.
earlier. And this, the same issue, there also, my lord, the state took an action to close down the check gates to prevent me from collecting customary tolls. And the matter came up and the order was passed, my lord. The next page, page number 163. My lord, with Lordship permission, may I read? Heard with sunset, the learned counsel for the petitioner also heard sunset, learned senior GA appearing for the respondent number 1 to 5. And Mr. Sunset, learned counsel appearing on behalf of the respondent 6, district council, my lord. Proceeding has been initiated with the following prayers. My lord, is page number 163. Volume 2, my lord.
163, yes.
Volume 2, my lord. The order dated 19/2/2013. Got it? My lord. Now, the prayer made in that writ petition, Lordship, can you see, in the premises aforesaid, it is therefore humbly pray that your Lordship may be pleased to consider the above called the records, issue rule calling upon the respondent number 1 to 5 to show cause as to why a writ of mandamus shall not be issued, declaring the closure of the toll gate leads to streets and such within the Mawlong Sidarship for collection of customary tolls should not be declared as illegal, and further, the seizure of the cash, coupons, and notebooks from the private lessee by Sicily stated sunset as illegal, and thereafter direct the respondents to allow the said toll gate to operate within the Mawlong Sidarship and not interfere with the operation of the same, and further to release the seized articles as mentioned in the Sicily sudden such. That was the prayer, my lord. Now, may I come to the last paragraph, the same page. The toll so collected has been used as a revenue in meeting various expenditure in connection with the developmental works undertaken by the petitioner and his darbar for the upliftment of the people residing within the darbar aforesaid. In order to collect the tolls, the petitioner with approval of the darbar appointed one such to collect tolls on the goods laden out from the sitarship, which petitioner is a sitar. On being so authorized by the petitioner and his darbar, the private lessee started collecting the tolls from the good and merchandise taken out from the Mawlong Sidarship. However, on such, the police from Shela Police Station, led by the respondent number 5, who is the officer in charge of the Shela Police Station, came to the collection site and forcibly stopped the private lessee from collecting the tolls within the area which falls under the jurisdiction of the Sidarship aforesaid. What is worse, the police not only seized the coupons and money amounting to such, being the tolls collected from different persons, but also arrested the private lessee only to be released on bail subsequently. Such a conduct on the part of the respondent authorities are not only a great example of high-handedness, but total trample down the authority and jurisdiction which the petitioner and his darbar has over the matter of collection of tolls should be used for welfare of people living within the aforesaid area aforementioned. Yet another thing that has been highlighted to show the high-handedness on the part of the respondent authorities is that the action has been taken without serving any notice on the petitioner or the darbar of which he is a part. This only shows that the respondent authorities did not care even to address the minimum requirement of law, constitutional, statutory, as well as natural law. Being aggrieved, the petitioner has approached his court by way of filing the WBC and such with the prayer aforesaid. Along with this proceeding, in this case, praying for direction requiring respondent number 1 to 5 not to interfere with the collection of the customary tolls by the petitioner from the area within its jurisdiction till the disposal of the proceeding has been filed. A further prayer was made to the effect that the respondent authorities may be directed to refund the money, seize money from the private lessee as well as other things and documents from him when respondent under the leadership of respondent number 5 had visited the Sidarship on sunset without any further delay. I have heard the learned counsel for the party as well as the state respondent. As agreed by the parties, it has been directed that till the disposal of the proceeding, the respondent number 1 to 5 shall not interfere with the writ petitioner from collection of tolls which they reportedly do under the all age tradition and custom. However, they will maintain a proper account of receipt of tolls so collected and also maintain statement of expenditure incurred in connection with various developmental works said to be for the benefit of the people living within the territory of Sidarship aforesaid, so that those statements can be produced before this court or any other appropriate authority as and when same is required. In respect of prayer for release of seized money and other articles documents, the petitioner is advised to prefer application before the appropriate authority, seeking release of the same on furnishing relevant documents. On receipt of the appropriate prayer from the petitioner, the authority concerned, namely such, would do the needful in accordance with law. With the above observation direction, this proceeding is disposed of. In fact, my lord, the writ petition was disposed of in this term. That from that day, my lord, they did not interfere my collection and continued until, my lord, the impugned order which we challenged before the single bench, they issued the impugned order. And now, impugned order, may I just take the same volume, page number 168, the same volume, my lord. Page number 161. So from 2013, I continued to collect customary toll. In 2016, they issued this impugned order. At 168, with the type copy, may I read?
168.
Yes, madam. This is the impugned order we challenged before the single bench. With reference to subject cited above, I am enclosing here with a copy of the order pertaining to detailing the magistrates for dismantling of toll gates in East Khasi Hills district. In this connection, I am requested to kindly depute magistrate in place of Sri Sansaj EM for dismantling the toll gates at Ichamati. This is my toll gates, my lord. East Khasi Hills, run by Sri Reyes Bhawa, authorized by Maulana Siddharship, collecting rupees 200 per truck of coal limestone boulder as it was under your jurisdiction. A copy of the High Court order 5WBC number such dated such is enclosed herewith for ready reference. Now, my lord, the sole basis for issuing this impugned order is based on the High Court order. It is not that, my lord, the toll gate has obstructing the free flow of the traffic or other grounds. The only reason is the High Court order. Now, my first limb of argument, therefore, is the earlier round of litigations, there was admission on the part of the government, so they did not file an appeal. And that order passed by the Guwahati High Court has attained its finality also. So the principle of res judicata, in fact, comes into play. That would preclude the respondent to raise the same issue again and again. Therefore, impugned order itself is illegal. Now, second part of the issue, where, my lord, the issue relating to whether the customary authorities has the customary right to collect the customary tolls in their jurisdiction. It was debated, addressed the issue, and settled by the Guwahati High Court, where the HA has referred last time. I will come to that one. My lord, if we revisit that judgment thoroughly, my lord, the issue involved here, raised by the state government, will be very, very, very clear. Now, the learned HA in the last occasion refer the Supreme Court order, Ghazi case, and Mr. Rimbai case, reflected there. Those two orders also reflected in the commercial case. Now, if I invite Lordship judicious attention to that judgment pronounced by the division bench of the Guwahati High Court, I may come to the different volume. It is given in different. Well, I may come to the first volume, volume number 1. Volume number 1, page number, my lord, 121. Started from 121, compilation. My lord, here the brief background of this very case, Guwahati High Court case, Meghalaya commercial case, was that Meghalaya Commercial Drug Organization had filed 2 writ petitions before the Guwahati High Court, challenging the collection of the customary tolls by the non-CMships, Siddharships, and district councils, saying that this affect their fundamental right to freedom of trade and commerce. And another writ petition was filed by, my lord, Million CMship, the customary CMships, challenging the, my lord, the action of the government interference with regard to collection of the customary tolls. Now, these 3 writ petitions were clubbed together, and matter was heard by the division bench. Now, the issue raised therein, the core issue raised therein, the same one, that whether this customary organized association, institutions, has the customary rights to collect the customary tolls or not. And that customary tolls is saved by the Constitution of India, or it runs contrary to the Constitution of India or not. Now, the prefix, I just show, my lord. May I come to page number, it'll be very clear, page number 124. Para 1 to 5, these are the prefects, my lord. The same case, my lord. I will, my lord. May I?
Page 124.
124, my lord. May I start from para 1, my lord. So that if the background is clear, my lordship, it will be more easy to appreciate the issue involved there. The decision bears on the validity or otherwise of the collection of tolls at the check gates set up by the respondent district council. This CMs of different ilagas, like presented writ petitioner, located within the West Khasi Hill district of the state of Meghalaya and their leases. Whereas the petitioner in WPC number 2 questioned the authority and power of the respondent CM to do so. The petition WPC CM of Milliam and his third seek an appropriate writ to restrain the state respondents from obstructing his or their leases from collecting such tolls within the same ship. Viewing the striking identicalness of the issues to be attended, the related pleadings being minimally at variance, analogous hearing was the consensus, and this adjudication would answer the debate. We have heard the learned A. Sharma, senior advocates, assisted by but I may skip. But number 3, skilledly, the rival pleadings in bid need to be adumbrated to lay the preface for the contention plea seeking resolution. The petition WPC Sunset has introduced itself to be an association of truck owners, operators committed to the goals of its members plying their trucks on public roads, including national highways, laid in the state of Meghalaya. Its members are engaged in business of transporting coal and agricultural products for such. They utilize the national highway Sunset, which is constituted the lifeline of the coal-bearing region of the state, as disconnect it with the rest of the country. It has alleged that such trucks carrying commercial loads of the aforementioned items while plying on the public roads, including NH Sunset, connecting Nongstow and Shillong, are intercepted at check toll gates set up by or on behalf of the Khasi Hills Autumn District Council and the responding CM ships, and are subjected to exaction presented to be tolls without any authority of law. In its pleading, WPC, the petitioner has enumerated as headed under 8 such points where the trucks of its members are stopped and such payments are realized. These are the places: Nongstow CM ship, Mariao CM ship, Hima Molang Sidar CM ship, Khasi Hills District Council. Another is Khasi Hills, CM of Hima Nongklaw, and KGDC. Now, the main argument of the case here of the writ petitioner is, reflected from para, is the problem. Just refer to relevant para, with lordship permission. May I start from, para 17. 17. The sole argument of the writ petitioner, challenging the authority of collection of tolls. Well, 17. In the backdrop of this mammoth and the contentious pleading, Mr. Sharma has consistently argued that the CMs of the areas involved had never been the territorial sovereigns thereof, and prior to the framing of the Constitution of India, amongst others, exercised a limited traditional right to collect tolls from those who sold goods in the market located within their jurisdiction. Relying on the authoritative text titled, "The native races of India by such and such, collection of treaties, etc., compiled by such and such, notes on Khasi law," Mr. Kenley, the Learned Senior Council has argued that the CMs are not authorized to collect tolls beyond the said territorial limits. Mr. Sharma has argued that this limited right of CMs ceased as the administration of the said area stood vested in the District Council as mandated by the Constitution of India, whereafter they only acted as its District Council officers and could exercise only the powers conferred by it. No traditional right of the CMs, including that of collection of tolls, was safe by the Constitution of India, he insisted. As in any view of the matter, Rules 2006 being beyond the framework of Act 2003 are per se inoperative, null and void. The action of the CMs to set up toll gates and to collect tolls are purely executive acts without any sanction of law and are thus obviously illegal and unconstitutional. In order to drive home this plea, the learned counsel principally relied on the decision of the Apex Court in Tigazzi case. On the day before yesterday, also learned AG relied on Tigazzi case. Same reliance was made. Referring to Para 8.3 of the 6th Schedule of the Constitution of India, the learned senior counsel maintained that though the District Council was empowered to levy and collect tax as contemplated therein, the allegation of such power to the CMs was not comprehended per se. According to the learned senior counsel, a District Council, albeit through regulations made by it, could provide for levy and collection of any of the taxes specified in paragraph 8.3. The said ipso facto did not signify the CM's authority to exact the same. Contending that Act 2003 was not a law, regulation in Visak under paragraph 8.4 of the 6th Schedule, Mr. Sharma argued that rule-making power contained in section 13 thereof could by no means be invoked to provide for levy and collection of tolls, and that too by the same and his third part. This indeed is in contravention of the preemptory inhibition contained in the Article 304 of the Constitution of India. As imposition of tolls contemplated by Rule 12 has the impact of impeding the freedom of trade or commerce or intercourse guaranteed under Article 301 of the Constitution of India, none other than the legislature
These are all
of the
the
state.
submissions.
These are submission of the my lord.
Yes.
Similar submissions advanced by the learned AG. So this is the submission. And now the submission of the government, it will be interesting to my lord to see. Para 20.
Para 20.
Para 20.
Yes.
In Para 20, my lord, they have filed the affidavit. Let's see, my lord, the content of the affidavit. Para 20, my lord, the submission of the government. Mr. Todi learned AG, Meghalaya, while affirming the power of the District Council under the 6th Schedule of the Constitution to enact laws for collection of tolls by the CMship.
Mr. Counsel, you need not read the entire thing. You point out the submission made by him is reflected in this judgment,
yes,
and which has been considered by the Supreme Court and are identical. That is enough.
Okay. Then, my lord, then I'll come. Here the state has filed an affidavit, not disputing the power of the District Council to enact a law, empowering the CMship to collect the tolls. State has admitted. Now the present proceedings where learned AG has referred that the collection of the toll is in contrary to the judgment rendered by the Supreme Court in Kazdi case. My lord, in the last occasion he referred. My lord, that page, the earlier division pen here also refer. Lordship, kindly come to para, my lord, 28.
Yes.
Well, para 28, my lord. It says, my lord, the lucidity and the comprehensiveness of the factual recital imported in D. Gazi Supra promise to follow therefrom, in essence, the sequence of events to project the factual backdrop. Before the country attained independence in the years and such from the British rule, there existed 25 Khasi states in the northeastern territory, thereof, with equal number of chiefs who were elected by the electoral college or the people generally, the process being confined in most of the cases to their members. Now, look, it's a historical background, the narration. Now, I may skip that one. Lordship, may kindly come to para 32. Para 32. After referring the Kazi judgment, the learned division Penji came to this conclusion, madam. Para 32, it says, on reading between the lines, This decision does not seem to address in particular to the issue of collection of tolls by same or chief of the SOL Khasi state as a symbol of age-long customary practice. The contextual facts bearing on the issue seeking adjudication did not warrant the attention of the apex court to that effect. The conclusion that with the induction of the Constitution of India, the powers of the administration of the 10 chiefs of the Khasi states had ceased, thus has to be construed in the background of the contention raised and the issue's answer. This finding, as evident from the decision itself, is not extinguished of all the customs prevalent as it records that the respondent CM after his initial appointment by the governor and as confirmed by the district council had been conducting the affairs of his ilaga in accordance with the existing customs and customary laws as approved by it, district council, as well as in conformity with its rules and regulation in terms of his appointment. The essentiality of the conformance with existing customs and customary laws as approved by the district council by the same was thus recognized and recorded in the decision. Now, my lord, basically, my lord, the learned division bench say that because the issue is altogether different, in Gazi case, district council has suspended the chief. And the chief has taken the plea that unless you enact a law under the 6th schedule, you have no power to remove me. That was the issue involving the Gazi case. Now, the learned division bench of the High Court says that the issue is different. The customary collection of tolls was not at all an issue in Gazi case. Therefore, Gazi case is not applicable with regard to collection of customary tolls. Now, learned AG also referred to Rimbai case. Well, now, that was also relied by the then petitioner. That one, my lord, page number para 25.
30?
Para 25 of the judgment, same judgment. This judgment also heavily relied by Mr. Sharma for the petitioner. Para 25, at the ending part, Lordship kindly see District Council of Joy, Autonomous District Council Joy versus Duit Singh Rimbai. Last time AG relied on this. Now, what is the finding on this by the Honorable Learned Division Bench? My lord, that answer we can find in, my lord, para 80 of this very judgment. Para 80, man. 80. Running page will be running page 155. Para 80. That also, my lord, examined by the Learned Division Bench. Para 80, running page 155. If Lordship got it. Para 80. May I read, my lord? The Apex Court in District Council of Joy Autonomous District, Joy and others versus Duit Singh Rimbai, Sita Supra, while recognizing the power of the District Council to levy tax specified in paragraph 8 of the 6th schedule, observed that the same did not extend to any one or more of the subjects enumerated in paragraph 3 thereof. Their lordships, however, clarified that there was no specific reference to the power to levy any fee in respect of any matter mentioned in paragraph 5, having regard to the nature of such realization or services rendered. The power to levy the same ought to be necessarily implied. Therefore, here, my lord, if we look to the para 5 of the 6th schedule, District Council has the power to make a law for election succession of the chiefs and headmen and for the administrations. Now, in that Rimbai case, my lord, I take that very judgment, Mr. Rimbai case. It will be in the volume, my lord. I think. Sure. Volume. Rimpoy case, my lord, in the compilation is there, my lord. Yes, my lord. May I come to the second volume? Well, volume number 2, page number, my lord, 196. One 96, my lord. Second volume number 2. Page number 196. 196. Relevant para, I will refer, my lord, only to 2 paragraphs, paragraph 11 and 21. Para 21 or para 11 first. It is seen from paragraph 3 in paragraph 8 of the 6th schedule of the Constitution when they set above that the district councils and district regional councils, in addition to specified executive functions conferred on them by the order paragraphs in that schedule, have been given legislative powers in respect of certain topics mentioned in paragraph 3 and power to levy the taxes specified in paragraph 8 of that schedule. The powers enjoyed by these district councils cannot be equated with the plenary powers enjoyed by legislature. Their powers to make laws are limited by the provisions of the 6th schedule. The courts cannot constructively enlarge their powers to make laws. The earlier, my lord. Paragraph 3 and 8 of the 6th schedule of Constitution follow almost the same pattern in which subject in list 1 and list 2 of the 7th schedule of the Constitution have been enumerated. While the subject relating to taxation are dealt with separately in paragraph 8, paragraph 3 does not contain any subject which authorizes the district and regional council to levy taxes. Paragraph 3 confers power on the district councils to make laws only to regulate matters specified therein. Paragraph 3(1)(b) empowers the district council to make laws with respect to the management of any forest not being a reserve forest. Paragraph 3(2) defines a reserve forest as any area which is reserve forest under the Assam Forest Regulation 1891 or any other law for the time being in force in the area in question. Now, this will be a relevant matter. It may be also noted that there is no specific reference to the power to levy any fees in respect of any matter mentioned in paragraph 3 in the 6th schedule to the Constitution, similar to the corresponding provisions in the penultimate entry in list 1 and the last entry in the other 2 lists in the 7th schedule of the Constitution. But having regard to the nature of the fee, which is an amount levied as quid pro quo for services rendered, the power to levy fees in respect of any of the matters mentioned in paragraph 3 would be necessarily implied. But such fee should not be disproportionately very high, that is tax in disguise. The Act was enacted for the purpose of making provision regarding the management and control of forests, which are not reserve forests, in the area within jurisdiction of the district council in exercise of the power conferred by paragraph such and such. Now here, my lord, according to me, the Honorable Apex Court held that under para 3, district council has the power to enact a law. But power to collect fees is not mentioned specifically, but it is implied in nature. That is, my lord, if the district council bring a law with regard to functioning of the CMship, for example, for the election, nomination, suspension, administration of the this local authority, village, the customary authorities, the Apex Court say it is implied. They have to function it, therefore, to function the customary institutions, they have the right to collect the fees. Now, with that, may I come to with regard to this, my lord, may I come to yes. I'll come to para 21, the last part of that Supreme Court judgment. Para 21, it says, in the result, this appeal failed and they are dismissed. But we, however, set aside the finding of the High Court that no fees can be levied by the District Council in respect of matters enumerated in paragraph 3 of the 6th schedule to the Constitution. The High Court has returned a finding that District Council has no power to bring any law empowering the Council or the Chief to collect any fees under para 3. That was the finding written by division bench of the High Court. So Supreme Court say no, that finding is wrong. Finding is wrong. Now, the enactment number I will show, there are many enactments made by the district councils on the same para 3, read with para 8 also. In my case, the same act is in my Maurong Siddharshi. The act is there. The act is there. Now, may I come to that, my lord, relevant portion of the finding of the division bench of the High Court in the Meghalaya Commercial, volume number 1, my lord.
Shall we continue? Is it 1:15? Shall we continue after lunch?
Yes, Lord.
Ready. How long will it take?
But we will take some time, but it's a very important matter. It will affect many institutions. It's a vital issue.
Give the bullet points like him. Give the points, then you argue. Otherwise, you are going to read the entire judgment, it's not going to help.
My lord, I'll not read the entire judgment. I'll refer to a few relevant paragraphs of Meghalaya Commercials.
Whatever judgment he referred, you must distinguish it. Because you are a distinguished lawyer. So do that and give the bullet point. That is enough. You need not read the entire thing.
My man, I'll try to concise my argument. Definitely.
Is it 45 minutes? Half an hour?
I'll admit
half an hour. So we'll resume at 2:15.
2:15.
Then finish it by 2:45. Then you give bullet points by him.
Yes.
And it will be a week's time.
Yes.
So that it will be easy for us. We'll post the matter and thereafter we'll close the warrants.
Yes.
Continue at lunch. At 2:15.
2:15.